from IP Santarém, whose work focused on digital culture, innovation, and open knowledge. If you have any questions or comments, please use chat, and at the end, Professor Artur will try to reply to all. Thank you all for joining us, and now, Artur, the floor is yours.
Okay, thank you. So, good afternoon all. My name is Artur Marques, and I will be talking with you about creativity and intellectual property. I will be using this style of presentation because sometimes I might enjoy selecting some words for some purpose. Creativity and intellectual property. As creators, in order to put food on the table, we depend on the revenue streams that intellectual property law allows us. And as we tag along this presentation, we shall talk about generative AI, code, knowledge, intellectual property in general, and also open source as a facilitator of inclusive and transformative processes. Many times there will be occasions for me to say that words are not innocent at all. For example, right here on the title slide, the word code is not innocent. Also, the word transformative is not innocent. Why are they not innocent? Because code might suggest that I am talking about computer source code, but in reality, I am talking about in any form of intellectual output fixed in some information support. And regarding transformative, it is also not innocent at all, because intellectual property law is not only about giving opportunities for creators to collect revenue streams from their creations, but also about creating exceptions so that the society as a whole can benefit from those creations. And it is precisely on the exceptions chapter, the so-called fair use chapter in the case of US copyright law, that the word transformative is really relevant to make the case for some unexpected or expected, it is subjective, exceptions. But maybe we can begin with concepts. The presentation, if we measure it by number of slides, is long. I have 45 slides. But in reality, I would say the first 20, maybe less than 20 slides are really important for us to understand the foundations of creativity and intellectual property, and the final slides also important to understand the current present context very much influenced by generative AI, but some middle slides are there for very specific, for example, open source licenses. So I will try to reserve some minutes in the end for some discussion that might be required. So starting with the concept of creativity, there are many perspectives on creativity. This slide presents you two perspectives. One of the perspectives is wonderful, captured in a big paper, but any perspective will probably pick on the adjective novel. So, there is creativity when the intellectual output is different enough to be called novel. And this very much aligns with intellectual property law in general, because in order for some intellectual output to be worse any protection, it must satisfy the so-called originality requisite. And originality is precisely the novelty here mentioned. Well, the concept of creativity might seem simple enough, but it has been changing. For some people, creativity is something exclusive of human beings. And for example, a monkey that takes a picture of itself cannot be considered creative. And this would guide us to a very famous court case titled The Monkey Selfie, precisely. But the monkeys these days are not primates. We are talking about computer systems, the so-called generative AI systems, which exhibit statistically based behavior that in the end outputs productions that in many cases can be considered different enough from other productions so that we can say it seems to be creative. But these systems debut some questions that in order to be understood require us to delve into words such as model and training data, but the questions I mention here are: so if I use a generative AI system to assist my creative worker, who is the author? Is it me? Is it the AI model? The word model is one of those not innocent at all words that I shall explain in a minute. Is it me writing the prompt? Is it the developers who constructed that sophisticated computer system? Or maybe the authors of the training data? So in order for us to better understand these questions, first let me pick on the word model. Formally, in artificial intelligence, a model is a function. So it is some process who receives data as input, usually, not always. We call the data a sample from the data set, and the output can be, for example, a classification of the sample. For example, if the sample is 30 seconds of music, maybe the output is electronic music. If the input is the vectorization of some flower, maybe the output is Virginica setosa, meaning the species of the flower. That would be a model for AI classification, but not all models are for classification. Many models are for regression, for example, so for the approximation of numbers. Regardless of what they are, models are like functions. They have input data, they have some form of output. And it is precisely regarding the input data that we need to talk about training data. The training data is the data set. It is the samples that were used to present the system some natural or artificial occurrences so that the system can learn from them. So these questions are relatively new. These questions are new for the world of machine learning, and there is a spectrum of views on these generative AI systems. A spectrum that goes from the polo that says, well, these systems are a situation of transformative fair use, to the other side of the spectrum, which is they can be that, but mostly they are mass-scale copyright infringement. Why both of the views have some ground, and there is plenty in the middle too, but picking only on the extremes. Again, the word transformative. it is very obvious that generative AI brings the world new forms of approaching problems and of using computers to do intellectual work. So they transform intellectual work. And maybe the way the transformation is happening is a situation of fair use. Again, fair use is an exception to copyright law. Maybe these systems are so different and are enabling such productive gains that even if technically they are infringing copyright law, they must be allowed. The same way that in the era of global World Wide Web boom, projects like Google Books were deemed fair use. So Google harvested millions of books from millions of authors and made those books searchable over the World Wide Web, which is great for people to find content that they would otherwise never find. And when authors and publishers took Google to court, it was considered that projects such as Google Books were so relevant in leveraging new forms of searching and finding knowledge for people in general, for the society as a whole, that it is a case of fair use. But nevertheless, on the perspective of many of the infringed authors, what is happening and what happened back then is a copyright infringement. So as we shall understand in the next slides, copyright is an economic instrument given to authors, given to people like you and me, that enables us monopolies, exclusive rights, meaning the right to exclude others regarding what can be done with our creation, who can copy, who can modify, who can distribute it. And if we have those exclusive rights, it shouldn't be Google or OpenAI or any other organization to decide, I'm going, without consulting, without asking, to pick someone else's work and do something with it. So this is the other side of the spectrum. There are many cases in court, of course, against generative AI companies. And although many of the cases are far from being decided, because there can always be appeals unless the ultimate superior court has pronounced itself, because many of those cases are yet to be decided, we can think that there is a chance, in fact, for the courts to decide that generative AI is a mass copyright infringement situation. But in reality, the probabilities are in favor of transformative fair use, because there are many precedents from the World Wide Web boom, many situations where the knowledge of the world has been crawled and organized in ways that indeed proved to have been of benefit to the society as a whole. So this is the current state of creativity. We are now living on a world on maybe creativity is something not only by humans, but also by machines. The question is, as we shall understand by the end of the presentation, there is no protection in copyright law for even if creative outputs are indeed in the line, there is no protection for outputs from machines. So in order to start to understand this, we must start to understand intellectual property in abstract. So knowledge is something very special. I'm not going to try to define knowledge in philosophical terms, but I'm going to pick the economics side of the thing. So in economics, knowledge is what economists call a public good. Some slides away, there is a classification of public goods, but basically it is something that when you consume it, you don't impede others of doing the same, contrary to an ice cream, for example. So there is no rivalry on consumption. And also, once the knowledge is open, you cannot expect people to drop the knowledge. So you cannot impede people from accessing knowledge. And because of these two properties, non-rivalrous consumption and non-excludable consumption, economists call knowledge a public good. And this problem has been worked by many people. One notable person working on knowledge and its dissemination to the society as a whole is Thomas Jefferson, which was United States third president, but for the purpose of this presentation is most relevantly known as the world's first patent examiner. So this was the first person who received applications, who claimed to be non-obvious, achieving some results, and people demanding economic rights over their inventions for a period of time. That other form of intellectual property protection is called the patents. There are only 4 types of intellectual property protection in the world: copyright, patents, trademarks, and trade secrets. We shall take a look at all of them, but the purpose of this slide was to make it clear that knowledge is not easy. And not only in terms of philosophy, but also in terms of economics, and other concepts must be clarified as we go on. In the title slide, open source was mentioned as a facilitator of inclusive and transformative processes. Well, what is open source? Let's work on that. Open source is not synonymous of free, a free intellectual property, a free software. Free software is also not synonymous of gratis software, of no cost. When we talk about free intellectual property in general, or free software in particular, we are talking about freedoms, not price. And usually the freedoms are the freedom to use as we want, the freedom to modify as we need, and the freedom to distribute with modifications or without modifications if we see as useful to distribute it. Open source is different. Open source just means that the intellectual output is made available to the society. It is open, but it does not clarify under what terms or what conditions. In the world of free software, there must be some document, usually called a license, that clarifies, now that the intellectual output is on the open, what can and cannot be done, and also what must be done. Because many of these licenses, as again we shall see, are viral. They make conditions that attach to the knowledge and what can and must be done with it, and become perpetually attached. So the purpose of this slide was to clarify that there is a difference between free software or free intellectual outputs or free knowledge and open source knowledge or open source software in general. In the software community, there is a blend of the two in the expression free and open source software. So, as authors of code, of music, let me say that software code is under copyright law considered literary work, so under the same category as novels, romances, and so on. As authors of knowledge, we create knowledge outputs, and we would like to be rewarded for those knowledge outputs. But in many situations, it is more valuable to us to keep it in secret. So imagine, for example, that you invented some form of rubber, which is significantly different from today's rubber, better sustainability, for example, and you think that you will profit more from your invention by keeping it a secret. Yes, that is a possibility, and the public policies around intellectual property try to give you incentives, to try to incentivize you on not pursuing that secrecy, to do the contrary, to open to the world how you did your novel Rubber. And the counterpart of you opening your creation to the world is that you will receive monopolies, exclusive monopolies over your creation for a limited period of time. So the idea is to work out a balance between rewards to the creator and yet the opening of the knowledge to the society as a whole, so that derivative works can happen, and so that others can start applying that assumed to be better process in their own activities. So, in general, intellectual property laws conceive four categories of protection, which are copyright, the most common, patents, trademarks, and trade secrets. Let me introduce them right now, but we will explore a bit deeper later. So copyright is about protecting the expression, the verbatim expression, not the idea behind the expression. Patents is, on the contrary, about the idea, but there are no protections for ideas in intellectual property law. The idea must be described as a process, as a sequence of steps, described as something that achieves some results, which are to be claimed in a specific section of the document, because in the end the patent is a document where the most important part is the so-called patent claims section. Both copyright and patents have something in common. They will expire. There is an expiration date on any copyright and on any patent protection. The idea behind the expiration date is so that a time will come where the society will pay nothing to access the intellectual output, either in the form of copyright or in the form of patent. Trademarks are different. Trademarks don't have an expiration date. They are also different because they are not so much constructed thinking about the creator and the society as a whole, but more thinking about organizations that care about confusions that might happen between brands of them and other brands, products of them and other products. And so, in the case of trademarks, the trademark is always active if the organization provides evidence that it is defending its trademark. For example, if you draw a logo very similar to Mickey Mouse's ears and face, you will be probably asking for trouble with Disney. In fact, this is a very interesting situation because these forms of intellectual property protection are all related. And in the case of Mickey Mouse, for example, although it is no longer under copyright protection, in fact, it is still dangerous to use Mickey Mouse in works. Why? Because of trademarks. Because the Mickey Mouse is one of the graphical expressions of Disney. And if you do something with the expression of Mickey Mouse, which you can do because it has expired, the copyright on Mickey Mouse, maybe you will encounter problems with the trademark. And in fact, that is what is happening. So trademarks are very much different. They don't have an expiration date. And they are more about associations between expressions of a brand with something than with thinking about rewarding the intellectual output of a creator. And the trade secrets are even more different because in trade secret, the protection is in not opening the knowledge at all. So these are important concepts to consider as we proceed. And in this slide, I just want to highlight some words. The word exclusive. Exclusive means exactly what it reads. A creator who has exclusive rights, which happens in the case of copyright and patents, has the rights to exclude others. So take it by its literal meaning, the word exclusive right. And exclusive rights for what? As we mentioned before, creators who have copyrights or patents decide who can use their inventions, who can read their books, who can modify their characters in books, for example, who can distribute and how the distribution can be done. And it is whatever the creator decides. When there is a problem. There is a problem if someone else tries to infringe on those rights, and that attempt creates compromise for the economic profit of the creator. So it is important to understand the concept of exclusion. Because nearly all the entire intellectual property law is around the negative rights, meaning the right to exclude others. Okay, so this is more of the same. If you have excluding rights, you also have including rights. Basically, this means that you can sell your rights, and in many cases, creators, this is very common in the world of audiovisuals and music, creators in a globalized world usually sell rights to entities which are better equipped to establish mass deals with others for example, the distribution of their creations. So, as we mentioned earlier, copyright is about protecting the literal work. And in this case, in the case of copyright, we can think that any text, for example, is protectable, but in reality, very small texts are not protectable at all. And we can also think that copyright law has been the same as the years go on, but it has not. It has been changing. And one of the changes is around the so-called minimis doctrine. If your work diverges for a very fine margin from another work, or if what you did is something very minimal, such as a catchphrase, in the past, this quantity criterion was considered. Today, it is not considered. There is no such thing as the sweat of the brow today in copyright assignment. But what we must understand in copyright assignment is that there are exceptions. For example, a public library is a place of exception. In a public library, you can probably go borrow a book, and if there are photocopiers in the public library, you can use the photocopier there to make photocopies of parts of the book. So portions of the work, as long as they not compromise the income of the creator, in some circumstances, such as certain places, such as public libraries, might have situations of exception. And the entire set of exceptions is the so-called collection of fair usages. We also took a look at the classification of goods at the start of the presentation, where we classified knowledge as a public good. Where, well, here it is that classification better systematized, where we find the columns excludable and non-excludable, and the lines rivalrous and non-rivalrous, and any public good, such as knowledge here on the lower right quadrant, which means that there is no rivalry in consumption, and you also cannot exclude others from knowledge. So, starting with the copyright. Copyright, by definition, and one thing we might think is that I am talking about copyright from the United States perspective. Because, for example, these names are exactly the names from the United States copyright law. But in fact, in Switzerland, in Bern, by the end of the 19th century, there was a convention on copyright, and Portugal was one of the first countries signing that Bern Convention. And by agreeing on the convention, the signatory countries basically agreed on a common set of minimal protections by copyright law. And although expiration dates can vary, although some requisites can have slight nuances from country to country, in general, in the so-called first world, copyright law is very much the same. And so these are the categories where you can protect your work. If you write computer software, you are writing literary work. What you cannot find here is, for example, prompting for generative AI systems, because although it is not acceptable to use the sweat of the brow doctrine, there is also a provision that explicitly states that there is no protection for small sentences and small phrases. So is generative AI prompting a situation of small sentences? When does a sentence become big enough? There is no objective answer in copyright law. Maybe it is 1,000 characters, maybe it is 4,000 characters. No one knows unless a court pronounces itself on that. And right now, the situation is courts don't accept generative AI outputs as protectable because they are not human creations. At most, we could think that the prompting could be protected, but there is no prompting category explicitly in copyright law, and there is a problem in integrating it in literary protection because prompts usually are not long by the thousand of characters. Okay. It is also important to understand that, for example, words such as choreographies can only be protected if there is a fixation. The word is exactly this. If they become fixed in some information support. So if you, for example, imagine a dance, imagine a steps on a dance, if you imagine a choreography, you will have no protection for it unless you tape someone dancing your choreography, or you do the schematics of the dance. You must somehow make it tangible in some information support system. Then it is automatically protected. This is also very important to understand. You don't have to go to some legal deposit to deposit there your work for it to have protection. In countries signatory of the Berne Convention, your work, as long as it becomes fixed in some information support system, it is automatically protected. However, if you fear litigation, the deposit in some entities, or in the case of source code, the publication in public third-party neutral repositories, can be used as evidence of you being the first creator of something. But what is relevant from this slide is that for any intellectual output to be worthy of protection, it must be fixed in some information support. This brings great questions which we shall not elaborate on. For example, regarding sculptures on the sand when we go to the sea. Some sculptures are very beautiful and take long hours to fabricate. Are they protected? Well, if you take a picture, because if a wave comes and washes them away and there is no evidence, there is no protection. There are many interesting cases in the story of intellectual protection. I will only mention them as interesting in the sense that these laws don't exist in isolation. For example, this case is absolutely brutal. This case between a now non-existent company and IBM put Linux into question. I don't know if you are aware, but if hypothetically Linux was deemed illegal because it infringed intellectual property from SCO's production, and if courts decided we must rewrite Linux, then you would have to rewrite, for example, Android. You would have to take thousands of satellites from the sky. what I'm trying to get to is that it doesn't matter at some point if something is technically illegal or not under copyright law. Because even if it was deemed illegal, the consequences of enforcing copyright, in this case in favor of SCOs, would be such that the world would stop. And that is not acceptable. And these are cases that precisely highlight that all these intellectual property instruments don't exist in isolation. Well, this slide details copyright in the United States. This other does the same. This other details patents. Again, as we mentioned earlier, in the case of patents, what is relevant? And the software can now be patentable as long as you describe it as a machine, as a process. What is relevant here is that there is an expiration date, and in the case of patents, it is not the expression that is protected. What is protected is the so-called patent claims. So, for example, imagine that you claimed, again, on the example of rubber, a rubber that does something. Imagine that someone else invents a much better process for the same rubber. If your patent claim claims the rubber itself, it doesn't matter how the rubber is achieved, more efficiently or less efficiently, because some patent examiner conceded you the patent. So many authors consider that patents have become not a tool for innovation, but an obstacle for innovation, because what is protected is what is claimed, regardless of the path that achieves the claim. So there are many interesting cases. Many have been depicted in movies that you can watch. Trademarks, we have already talked about them and mentioned that they protect association between suppliers and some intellectual outputs. Trade secrets are unfortunately on the growing. In the very final slide, we will link back to trade secrets, because one way to have protection on your generative AI assisted outputs is to not acknowledge that you use generative AI. So you keep it a secret, and as long as you can keep it a secret, you will have protection. But of course, if you are keeping something a secret, the society as a whole is not benefiting from your intellectual output. So we now achieve the middle section of the slides, which basically talk about different licenses. Licenses are, of course, alternatives to copyright. This is the important part. In copyright, because you have exclusive rights, you must write permissions, one per individual that wants to use your creation. In licenses, a thinker named Richard Stallman founded a philosophy of sharing, which is with a different approach. Basically, by default, you allow these freedoms and you don't have to create exceptions per individual. And the entire middle portion of the slide sets is on that topic. And the penultimate and antepenultimate slides go back to the start. So copyright and generative AI content. Well, we are now at a point where very recently, months ago, the United States Copyright Office reinforced its perspective that literally outputs of generative AI can be protected by copyright law only where a human author has been involved, meaning in the prompt, in, for example, text-to-image services or text-to-video services or text-to-something services, not in the output of the service itself. So the corollary is that the content generated by AI is not eligible for copyright protection. This has a great impact on today's life because many creators are being assisted by AI systems, and there is great uncertainty around what will happen in the future regarding revenue streams for authors, because it is getting harder and harder for authors to compete alone against these systems. So we need a change in the legal framework for intellectual property laws in general. Of course, I have no idea what the future holds, but like in open source communities, maybe collaborative creation should be explicitly recognized somewhere in the law. And in this case, the collaborative creation would be not with humans, but with artificial systems. And maybe the categories of protectable works can start to include prompts and curation. In the case of curation, I must say that compilations and derivative works are already protected by copyright law, although that was not explicit in the small list of categories listed earlier. So it seems that we need a new legal framework to recognize this hybrid human AI era, but we are not there yet. And in present day, what should we do as creators? What should organizations who with professionals that do intellectual output assisted by AI systems do? Well, the best practices seem to be to document the human creative contributions meticulously, explicitly, to understand that the current protection mechanisms offer nothing for AI outputs, and that will likely not change tomorrow. And so other intellectual property strategies, other than copyright, other than patents, may make a comeback. So trade secrets are on the rise, and this is quite a paradox. Where is the paradox? The paradox is that the same systems that on the short term bring great productive or can bring great productivity boosts, particularly for organizations and people and countries who come from a lower basis. The same systems that can bring those advancements can also bring closure, can also bring opaqueness, can also bring back the dark ages, where knowledge is not made public because the available incentives are not enough for creators to open them. And this is quite a paradox. And so this concludes my presentation. If you have any feedback, please do. Thank you.
Thank you very much for your inspiring talk. And as you have already said, if any of you would like to share some questions or comments, please, we will still have 5 minutes to the end, 7 minutes to the end. So please go through. Any question? So if there is no questions, I thank you all for your participation. And we are finished this webinar. Thank you again, Artur.
Thank you all for listening.
I also I'd like to mention that our next webinar will be conducted by Dario Rodrigues, and is take place on December 15, focus on current challenges and innovations in AI and digital ethics. I think Dario is here. Yes, he is. So if you can share something about your webinar, Dario? No, it's okay. So we can finish for now. Bye-bye.
Okay, bye-bye. Thank you all.